Today I rise in support of my amendment to House Bill 4500. Currently, House Bill 4500 reads, "For purposes of this section," referring to offense variable 9, "an embryo or fetus must be counted as a person." My amendment would change that language to, "For purposes of this section, an embryo or fetus may be counted as a person." In other words, when scoring the pregnant defendant under my amendment, the court would be given the discretion not to count the embryo or fetus as a victim of a crime, depending on the circumstances of that crime. This would not only defer to the court's judgment, but it would prevent women from being treated more harshly for crimes that may often be outside of their control. For instance, if a woman is injured in a car crash, she would not necessarily have to be charged for putting her fetus or embryo in danger, when she herself was a victim of that situation as well. My desire to give courts this discretion actually stems from the very court decision that this bill purports to be based off of. In that court's decision, the decision reads, "We therefore conclude that MCL 777.39, referring to offense variable 9, allows a trial court, when scoring offense variable 9, to count as a victim one that is acted on by the defendant's criminal conduct and placed in danger of loss of life, bodily injury, or loss of property." Additionally, a few paragraphs later, after the court acutely lays out all the number of other laws that already criminalizes the defendant's behavior in this case, the court further states, "Under the circumstances of this case, and without declaring the fetus in this case to be a person under the law, we conclude that the trial court did not err by counting the fetus as a victim for purposes of scoring offense variable 9. The court states in both their majority decision and the concurring decision the egregiousness of this specific case, which is why the decision of this court decision states a court is allowed but not mandated to count a fetus as a victim, because the court realized the facts of every case can be very different. If it was the intent of the sponsor to mirror in law what was decided in this case, then my amendment should be adopted. Otherwise, this bill is nothing more than an attempt to appease a certain special interest group. If you've been led to believe we are simply codifying a court decision, I encourage you to actually read the decision, because that is not what we are doing with HB 4500 as written. I hope you agree that by binding the court's hands, we are doing nothing more than potentially harming pregnant women and not helping them or their unborn child. Thank you.
Thank you, Representative. The question is on the adoption of the amendment. The clerk will open the board. The amendment is not adopted.